We are now live broadcast. We are on live cast. So those that might be watching on Facebook, we will be starting the webinar shortly. I'm just ready to start the webinar. So we'll be just now waiting for people to start to come in from the waiting room as they come in. We'll just give people a couple of minutes to come in. Good. Okay, and people are just coming in. We'll just give them a moment.
Yeah. Yes, they understood that. Yeah.
Yeah. So now we. Yeah. So we're just waiting for people to come in. Thank you to all that are coming in. If the panelists want to turn on their cameras at any point and be ready to unmute, we'll just be ready to start as we watch the numbers come in. And I think we could get going. Tara, we're about 2 minutes after, and I think most people are coming in from the waiting room now.
Okay. So welcome everyone to the webinar, Challenging Corporate Complicity and the Continued Colonization of Palestine, Means and Methods. I'm Tara Alami. I'm from occupied Jerusalem and occupied Yafa, and I'm currently based in Tiohtià:ke, which is known as so-called Montreal. I'm a Palestinian organizer and writer. I've organized on campus and off campus in the past with groups like Students in Solidarity for Palestinian Human Rights and the Palestinian Youth Movement, and I'm currently a graduate student. The co-sponsors for today's webinar are Just Peace Advocates, Al-Haq, and Canadian Lawyers for International Human Rights. Before we begin, I want to wish everyone who's observing Ramadan, Ramadan Kareem. And actually a link is going to be sent to the chat, because the Canadian BDS Coalition has a guide on their website with BDS-friendly Palestinian date brands and other brands to boycott all the time, but especially during Ramadan. And also, before I begin, I want to make note of the fact that every year during Ramadan, the occupation uses this month as an opportunity to escalate violence in all of Palestine. Yesterday, in the early hours of Ramadan, there were 3 men martyred in Jenin in the occupied West Bank with 200 bullets that went through their bodies. There was another martyr who was shot in the head earlier today by the IOF in Al-Khalil, also in the occupied West Bank. And there were also several arrests today and also during the past week by the IOF of young Palestinian men, one in Jenin and one in Tul Karam today. And also this morning, a child in occupied Jerusalem was sentenced to 12 months in jail by the occupation courts. I also want to acknowledge that I'm currently moderating this webinar from the unceded traditional territory of the Ganigahaga, which is also known as Mohawk. The Ganigahaga are one of the 5 founding nations of the Haudenosaunee Confederacy, and this island that is known as Montreal is called Tiohtià:ke in the language of the Ganigahaga, and it has historically served as a meeting place for Indigenous nations. We all recognize that Palestine and Turtle Island are both occupied territories whose native population has faced years of ethnic cleansing, and that in order to resist, and that decolonization is not just a metaphor for social justice and societal improvement. In order to resist, we need material repatriation and giving back of Indigenous land and life. And that this land acknowledgement is just the first step in fulfilling the constant responsibility to the Indigenous peoples and the land on which I am currently on, And we all extend our solidarity to the indigenous peoples resisting colonialism and imperialism from Turtle Island to Palestine to so-called Australia. Also, speaking of land, March 30th, a couple of days ago, was Land Day or Yom al-Ard, which is a central date in Palestinian collective memory. Land Day is a day where we commemorate the 1976 land dispossessions and the brutality of the occupation's response to Palestinian resistance. On March 6th, 1976, the occupation killed 6 Palestinians in cold blood when they were protesting the Zionist regime's plan to expropriate 20,000 dunams of land in Galilee or Jalil. Palestinians on the ground and in exile continue to protest and resist their dispossession and senseless murder of these 6 Palestinians. And the occupation at the time responded with even more genocidal violence. Since the inauguration of the Zionist settler colonial project over a century ago, the Palestinian people have endured and resisted ruthless genocidal violence that aims at dominating the whole land of historic Palestine by eradicating the native Palestinian population by any means necessary, whether through displacement, dispossession, exile, or just murder. And this makes the work that we are considering today critical as we continue our effort to disrupt the continued occupation of Palestine and genocide of the Palestinian people. So with that said, today's webinar is going to consider direct approaches to challenge corporate complicity in the continued colonization of Palestine, which includes judicial and non-judicial mechanisms. The panelists are going to share approaches that have been used to challenge corporate activity in occupied Palestine, including specific examples such as civic complaints, criminal complaints, and OECD national contact point complaints. And we hope that this will be a chance for activists and legal practitioners to consider both the legal and campaigning work that's necessary to hold these corporations accountable. We have Jonathan Kuttab, who's an international human rights lawyer, Wesam Ahmad, who's a Palestinian human rights advocate at Al-Haq, Kathryn Ravey, who's a business and human rights legal researcher at Al-Haq, and James Yap, who's a Canadian lawyer specializing in business and human rights. Before I move on to the panelists, I just want to do a little bit of housekeeping. The Q&A box is open. You can send your questions while the panelists are speaking. And the chat will also be, links will also be sent to the chat with resources. With the recent designation of the 6 Palestinian human rights organizations as quote unquote terrorist entities, and also earlier in 2021, other organizations that were defending justice for Palestine were, attacked with these smear campaigns in the media. We consider what is required of the international community, and in particular, those of us who are on Turtle Island or not in Palestine. So we will begin with Jonathan Kuttab, who is our first speaker. He co-founded Al-Haq in 1979. He's a well-known international human rights attorney, and he practices in the US, Palestine, and the 1948 occupied territories known as so-called Israel. He's currently the executive director of Friends of Sabil North America, and he's also a founder of Just Peace Advocates, who's one of the co-sponsors of this webinar and is on its board. He was the head of the legal committee that negotiated the Cairo Agreement in 1994. And after graduating with his JD from Virginia Law School and practicing a couple of years on Wall Street, he returned home to Palestine. He was also a visiting scholar at Osgood Law School at York University in Toronto, the fall of 2017, and he's a founding director, like I said, of Just Peace Advocates, which is a Canadian-based international law human rights not-for-profit organization. He's currently a resident of East Jerusalem and is a partner of the Kuttab, Khoury and Henna law firm in East Jerusalem. His writings have been published in the Middle East Institute, Arab News, Arab Center, Washington, DC, Al Jazeera, the Electronic Intifada, and also other publications. He's going to be giving us an overview of the international law and how to strategically use domestic and international law in the struggle for Palestinian national liberation. And he will also be giving us an overview of the situation of the silencing of the Sixth and the Canadian government's response. He will set the stage for specific cases, and he'll be talking about the role of law and activism in this context and how these things can come together, what we can do, and specific tools that can be used, including the comprehensive Palestinian human rights issues in Canada, legal and tactical guide, which was developed by Just Peace Advocates and provides basic information on legal issues that Palestinian rights activists may face and tips on how to navigate them. It also gives some generally applicable information and also campus-specific information for student activists, which will be highlighted during today's webinar. So Jonathan, the floor is yours. Go ahead.
Thank you very much, Tara, and thanks to all of you who are joining us today. I want to thank everybody who put this thing together, especially Karen. She put in a lot of work, and Al-Haq and its staff, which actually goes to what I'm going to be talking about. International law is a little bit different from a local law, because even though like ordinary local law, it basically depends on everybody following it voluntarily. You can't have a policeman and a court at every corner. Everybody has to drive on the right-hand side of the road, and everybody has to obey the traffic lights, etc. And enforcement comes to the exceptions, to those who, still knowing what the law is, go ahead and violate it. The problem with international law is that as it developed, it was really initially the practice of states. And states were the subject of international law rather than individuals or corporations. Yeah, but as international law became codified, especially after World War II, it became necessary for states to either sign bilateral agreements or multilateral agreements, or incorporate international law into its own domestic law. In addition, there were certain things that only states could do in international law. So even from the beginning, civil society and ordinary people had an important role to urge their countries to sign these treaties and to urge their countries to comply with them. And when these countries were reluctant, as many countries are, to engage in or to feel restricted by international law, civil society had to step in and urge first its own country to begin complying with it, and secondly, through nonviolent means like boycotts, divestments, sanctions, and protests, to try and bring international law into the lives and bring compliance with international law into some form of enforcement. This is true for every country. It's certainly true for Canada, which is, I think, where we are talking today. That is why it was necessary for Just Peace Advocates to be created, in order to use local law, first to defend those who are being attacked for their human rights advocacy on behalf of Palestinians, but also to urge the Canadian government to comply by its own obligations, particularly under Article 1 of the Geneva Conventions, which is that it needs to ensure compliance with the Geneva Conventions by all other countries. So I will stop here and reserve some of my time, maybe a little bit to the end, and we will see how, in fact, Canadian law can and has been used and should be used in order to promote compliance with international law, particularly the more outrageous violations of international law, to make sure that they are ameliorated or being stopped, and that countries and individuals are not allowed to violate international law with impunity. And that also includes not only governments, but also organizations and corporations who are complicit in violations of international law. I will stop here.
Thank you so much, Jonathan, for that introduction. And we'll circle back to you later. I'm going to move on to Wesam Ahmad, who is a Palestinian American born, who was born and raised in the US. He's a husband and father of 3 daughters, and he's currently living in Palestine. He earned his BA in political science and sociology and a JD from Louisiana State University. And he completed an LLM in international human rights law from the National University of Ireland, Galway. He's also worked with Al-Haq since 2006, engaging in international advocacy in various forms, including through the UN, the EU, and the ICC. And he's been published in the Business and Human Rights Journal, Al Jazeera, the New Arab, among other publications. He's also a former PhD candidate at the Irish Centre for Human Rights and a recipient of the E.J. Phelan Fellowship in International Law. But he recently decided to put academic pursuits on hold to focus on work and his family. His research interests focus on business and human rights and the economic incentive structure, which perpetuates the continued colonization of Palestine along business lines and the historical role of corporations therein. He's currently heading the Al-Haq Center for Applied International Law in Ramallah, in the occupied West Bank. Today, he's going to provide a historical overview of the evolution of the role of corporations in the continued occupation of Palestine by the Zionist entity, despite the development of international law within the context of the ongoing global process of decolonization. Go ahead, Wesam.
Thank you very much, Tara. Thank you very much, everyone, for the opportunity. I think it's good to be able to come right after Jonathan. The origins of Al-Haq and the work that we continue to do today through Al-Haq has evolved in part to challenge the continued inability of international law to be enforced. And I think it's important to highlight that a big reason why it's very challenging to do so is because there are economic interests at play. And my presentation is going to focus on those economic interests and the evolution of the role of corporate actors through the colonization of Palestine to the present day, and hopefully leave a good segue to our colleagues Kathryn and James to address some of the tools that have been implemented to try to challenge these corporate actors. If you'll allow me to share my screen here. Okay. So Jonathan mentioned the role of civil society in getting international law developed and having states sign on to it. And this has also been a historical process in parallel to the role of corporate actors in the colonial process as a whole. From the London Livery Companies to the British and Dutch East India Company to the British South Africa Company. These have been known as the commercial arms of conquest within imperialism and colonialism, and civil society has always stood up to challenge these injustices and the roles of corporations therein. And we continue to see that play out today. For those that are new to the area of business and human rights, I like to show a video of a speech given by President Allende in 1972, which helps to set the stage for understanding the fact that the issues we're facing today are not new. They are very much connected to the historical process of corporate actors and the challenges therein. And what I'll do is actually jump back to my presentation, because I think it'll be easier to just explain that in parallel to the development of international law, you had the challenges to decolonization, you had the challenges to the historical development of corporate actors throughout the colonial process, and the states coming to challenge this space of decolonization and liberation, and finding the challenges of corporate actors continuing to be an obstacle to the realization of true independence, true decolonization. And these actors continue to be an obstacle to the realization of rights today. And the process of challenging corporate actors from the 70s continued to today with an attempt to try to create a binding mechanism that applies to corporations, where corporations have obligations under international law, and putting this in a treaty format. But this is, again, an ongoing process that began in the early 70s, at the same time that we saw the codification of international human rights law. But those aspirations remain a challenge. But I think it's important for us to keep this sort of contemporary history of business and human rights and how we view it within the context of Palestine, because corporate actors have historically played a role within the Palestinian context. And in order to understand the Palestinian context, we have to see the Palestinian context within broader historical context, within broader geopolitical context. And so it's important to keep things in mind, like imperialism and colonialism, before we even get to the colonization of Palestine and the contemporary colonial occupation of Palestine in occupied Palestinian territory. Companies have played an instrumental role throughout the historical colonization of Palestine, and this role has developed depending on the interests at play. And one of the first companies to create sort of the strategic interest of Palestine within the world was the Suez Canal Company. The opening of the Suez Canal created an additional strategic interest of Palestine within the world. And once the Ottoman Empire went bankrupt, the British purchased the shares of the Ottoman Empire within the Suez Canal Company, instilling the British interests within the region, and therefore Palestine. And throughout history, you also see the interests of not only trade and the flow of shipping, but you also have the flow of oil and gas. And these are things that we see today as well. And one of the companies historically that was important was the Turkish Petroleum Company. Prior to World War I, it was a joint venture between German, Dutch, and British. But after World War I, the French and Americans came in to join the Dutch and the British in this oil venture. And this picture represents sort of the development of the oil interests within the region, particularly with regard to Palestine. You had the Kirkuk to Haifa pipeline, which still continues to be of strategic significance in the region. But looking at the layout of oil pipelines in the region should give you also an idea of the conflicts that we've seen of late throughout the region, and how conflict and energy continue to be a driving force of creating conflict within the region. Now, the development with the more contemporary sense of Zionism in Palestine has very much to do also with this evolution of how colonialism was viewed within the Palestinian context and within the Zionist movement. Herzl saw that there was a failure of what was known as philanthropic colonialism and moved towards adopting a more business-like approach, following the model of people like Cecil Rhodes in Southern Africa and the British South Africa Company. And over time, you had this slow appreciation for ensuring that there was an economic incentive that would come with fulfilling broader Zionist colonial policy. And this is laid out very nicely in an archival document titled "The Colonization of Palestine: Means and Methods" from 1925. And it asks a simple question: what medium should be employed to colonize a country on a large scale? Should it be done by philanthropy or treated as a business proposition along strict business lines? And so you see that this thinking about how the colonial project would continue within Palestine was very much connected to business interests and economic interests. And we continue to see that today. And I'm going to go through the rest of the presentation a little bit more quickly because I want to leave plenty of time for discussions. But you'll see throughout the course of the different slides that I'll put up company names. During the mandate period, you had the Palestine Electric Company, the Palestine Potash Company, Haifa Harbor. These were known as the Industrial Trinity, a term coined by Jacob Norris, of concessions that the British mandate gave to Zionist interests to control and support the Zionist project within historic Palestine. After 1967, you had the development of what I call the modern day Crown Charter Company, the Israel Corporation. And it was designed following the models of Crown Charter companies of the past, looking to create this economic model that promotes development using tax incentives and profits and dividends. Again, a modern day Crown Charter company that over time grew and spun off and developed into other smaller companies, but there were always connections to these broader economic interests coming from different parts of the world, sort of investing in Palestine and the colonization therein. And today we see the issue of gas very much on the table today. And so if we look historically, the issue of oil, and now we see the issue of gas. But not only gas, we have the depletion of natural resources, such as stone quarries, Palestinian resources being extracted to construct Israeli settlements, while Palestinian development continues to be stifled. You have depletion of the Dead Sea resources, which is also partly an occupied Palestinian territory. And these minerals also have strong economic linkages. You also have heavy machinery used to construct the wall and settlements. And all of this comes together in what I call the colonial subsidy, this architecture of exploitation of different natural resources and exploitation of Palestinian people and their resources to feed into the Israeli colonial project and subsidizing the broader Israeli economy. These are part of the challenges that we face, and every one of these sectors comes with a company or multiple companies that can be tied to its involvement. And all of these corporate actors are potentially complicit in the continued colonization of Palestine. And it is up to us to find creative ways to challenge those corporations in their activities in particular areas using the laws that we have available. Now, there are many companies, again, that are complicit, and there are many laws that can be used to challenge them. And it isn't one or the other. They're very much interconnected, as Jonathan alluded to earlier. And in order to understand the dynamics. We have to understand the system in which these laws and corporate actors come together, understand our role within the system and how we can influence the broader system and other social systems. And what I put here is an equation for us to think about solving for Palestine. The different variables that we need to take into consideration. International law and domestic law are only some of those variables. And my colleagues, James and Kathryn, will follow with some insights into some of those specific variables that have been used to challenge specific actors in specific contexts. So I'll end there and leave time for questions and turn it over to my colleagues, Kathryn and James. Thank you.
Thank you so much, Wesam. We actually do have a question for you that I think can be answered fairly quickly. Felix asked, why are the European commercial interests not equally inclusive of both the Jewish settlers and the Palestinians? Maybe I can begin the answer by saying that the goal of Zionism in and of itself is to be exclusive of Palestinians in any way, in whichever way that it's applied. But I'll pass off the mic to you to answer.
Yeah, well, I mean, the issue of exclusivity very much ties into the practice of apartheid and the control mechanisms that we have within occupied Palestinian territory. And it isn't the question being posed about the Europeans dealing equally with Palestinians and Israelis, I think needs to be turned a little bit to really understand the problem that Palestinians are not free to engage economically in the way that they choose because they are under occupation, and Israel limits Palestinian capacity to extract their own resources, to develop their own economy, very much connected to the Israeli economy and maintaining this dependency. So in order for Palestinians to be able to be on equal footing and deal with any other economic actors around the world, they need to be able to do so freely in order for there to be what we call a fair trade environment. But being able to engage in fair trade when you are not able to have free trade and continue to be under occupation is very difficult.
Yeah, thank you for that. And also, if I may add, with the historical perspective that you brought, I think it's very insightful. And I think it's also important to remember that this kind of exclusion of Palestinians from the economy was inherent to Zionist colonialism before so-called Israel was even made into a state. In the 30s and in the early 40s, settlers were organizing direct boycotts of Palestinian businesses and Palestinian labor. So this is very much something that's inherent to the Zionist project. If you don't have anything else to add, I'm going to move on to Kathryn. Okay, so our next panelist is Kathryn Ravey, who joined Al-Haq as a business and human rights legal researcher in 2021 after working at a law firm litigating civil rights violations like police brutality, wrongful convictions, and racial discrimination. She has a master's degree in human rights law from University College London and a BA in sociology and anthropology from St. Olaf College. Before receiving her degree, she worked for the Tahiri Justice Center, where she worked with and advocated for immigrant survivors of gender-based violence. Before that, she was a Werner Fornos Fellow at the Population Institute, where she conducted qualitative data analysis to measure the effectiveness of reproductive health education in rural Haiti. And a Mame Riley Fellow with the Democratic National Committee, where she worked with the Democratic National Women's Caucus to expand women's political efficacy. She worked with nonprofit organizations in India, advocating for women's access to secondary education, and in Northern Ireland, promoting peaceful reconciliation within divided communities. She's dedicated to promoting justice and engendering human rights throughout her professional and personal life. Today, she's going to be talking about the corporate actors that contribute to the water apartheid within the occupied West Bank and corporations involved in the Jerusalem light rail, including the CAF and WSP, which is actually a Montreal-based company that's responsible for the planning and the design of the Jerusalem light rail. And she will also be giving us an overview of the UN database. Go ahead, Kathryn.
Thank you so much for that very wonderful interjection. Very honored to be here. Obviously, there's a lot to talk about on this subject, but I will try to be brief. I guess, our overall question is, how do we ensure that the activities of corporations abide by human rights standards? And how do we promote accountability when violations of those standards occur? And this is in principle quite straightforward. Human rights obligations of each state require them to use all appropriate means to ensure that actors operating within its territory and subjects to its jurisdiction comply with human rights standards. But states generally dislike taking on more measures to ensure compliance by corporations. Implementing new accountability measures can be costly or seem beyond their capacity. And with globalization, it makes it difficult to identify who's responsible for what activities and where. So for those of you who are familiar, the guiding principles on business and human rights set out to clarify these legal standards. Yet they were created without a legally binding document. Instead, there was a push for a more diplomatic, multilateral approach to promoting greater legal clarification on these principles. So businesses and governments were quite favorable to this approach, but the fact that there was no legally binding agreement meant that this guidance lacked a complaints mechanism and that it would not ensure accountability for corporations that committed violations of human rights. So essentially, companies are strongly encouraged, but not obligated to respect human rights. And unsurprisingly, without greater accountability mechanisms, it's very difficult to mitigate violations of human rights that are committed by corporations, especially when they're utilized by an occupying power, such as Israel, to commit these war crimes. So it's in this context that I want to focus on an example of corporate entities that are evolved in the ongoing colonization of the OPT, occupied Palestinian territories. And I will first start with the company of WSP, which, as you mentioned, is headquartered in Montreal. This company is currently substantially contributing to the maintenance and existence of illegal settlements in the OPT. And it is doing this through the ongoing support of the extension of the Jerusalem light rail system. Now, this light rail system is used to expand Israel's illegal settlements in the OPT and in occupying eastern Jerusalem. And this is done by basically connecting and facilitating mobility between the settlements, West Jerusalem and Israel. So contributing really to this continued colonization of the OPT. So in doing this, the Jerusalem light rail enhances the quality of life of the settlements. It fosters and facilitates the growing settlements, and it deepens the physical, social, and economic integration of the settlements in the OPT, which is contrary to international law. The construction of the red line, which crosses the green line of into, hopefully you're familiar with this, this has already resulted in significant expropriation of Palestinian property and has contributed to many house demolitions in Palestinian villages and neighborhoods. This not only deprives the residents of Palestinian villages of their ownership and right to their agricultural lands, but it also occurs without Palestine's or Palestinians' consent. This is kind of what Wesam was saying as well. A lot of these corporate actors are invading lands and expropriating national resources without any sort of invitation, of course. And they do this at the behest of the occupying power. So WSP provides services to these trains, which crosses the green line into the OPT, and they're actively involved in the economic activities and relationships that reinforce Israel's illegal settlement enterprise. Similarly, in 2019, the team managing the public transportation system in Jerusalem awarded a 1.8 billion euro contract for the expansion of this light rail to a consortium, a Spanish consortium called CAF, which is, of course, an acronym. Now, this project included the extension of the existing red line, but also the construction of a green line, which expanded even more into the occupied Palestinian territories. This included the supply of vehicles, of technical services, and maintenance. So both of these lines connect illegal Israeli settlements in the OPT, as well as the western part of Jerusalem and Israel. So essentially, CAF and WSP are directly facilitating Israel's transfer of its civilian population into the OPT, which actually amounts to a war crime under the Rome Statute. Now, in 2020, the Committee of Solidarity for the Arab Cause actually filed a petition against CAF with 2 national contact points with the OECD. But more than a year after this submission, an assessment regarding these complaints has still not been released. And this is actually a breach of the OECD guidelines, which requires that an assessment of complaints be completed within a 3-month period. So as it is frustrating, you can see the lack of mobility with the built-in structures that already exist to bring about complaints and violations of human rights. Now, it's important to remember that both of these entities remain involved in this work because it is profitable. You know, CAF's participation in this business venture is valued at over 5 million euros. And they also will be managing the operation and maintenance of both rail lines, which is estimated to be about 1 billion euros in revenue. So clearly, corporations actively violate international law and play a key role in the dispossession and displacement of Palestinians and Palestinian resources. So of course the question becomes, what can be done about this? And as we've noted, there is a lack of strong accountability mechanisms within the world of business and human rights. But it is important that we utilize and strengthen the existing tools that exist within international solidarity and advocacy. And we want to use these tools to call upon states to take further steps in their obligation to end corporate violations of human rights. So one example of this is the UN database on businesses involved in illegal Israeli settlement enterprises. For those of you who are maybe not familiar, this is a database created by the Human Rights Council that raises human rights concerns about businesses who are involved with illegal settlements in the OPT. Now, this is a powerful tool for assuring that transparency of business enterprises are noted globally, and that everyone who makes it onto this database can be seen as actively profiting from Israel's apartheid regime. But there are, of course, challenges that come with this. For one, the database does not cover all corporate activity related to settlements. And there are several, hundreds of companies that are not currently listed due to interference from other states or just that have yet to be included. For example, in 2020, a report was submitted by over 30 human rights organizations from Palestine and Europe demanding that CAF be included in this database for its role in expanding and operating the Israeli Jerusalem light rail. But it has yet to be included. And we are in the process now of drafting a statement about the illegal actions of WSP, calling for it also to be included in the database. It has not been updated regularly, which is going to require a lot of resources and international solidarity to have regular and annual updates to this data so that all corporations who are illegally profiting from Israeli apartheid can be known and can be seen. And this is important because it can be used as a great tool for global advocacy. And a really good example of this is with WSP, actually. There's been a lot of advocacy around this, especially in Canada. If you don't know, WSP is heavily invested in Canadian public pensions. In fact, one major shareholder of WSP is the Canadian Pension Plan Investment Board. In 2020, WSP actually made up more than 53% of Canadian publicly traded equity holdings. So the board, the CPP investment in WSP is over 21,000 shares with a market value that's increased by over $1 million in the last year. And amazingly, in 2021, over 70 organizations from across Canada and the world, including Just Peace advocates, demanded that the investment board divest from WSP. And the board did acknowledge receipt of this letter and said that they would be reviewing the situation, as well as other companies that are already on the database, which is yet to be determined, but it is important that that information is out there and that people have a strong tool of requesting that companies or that states and larger finance groups divest from Israeli apartheid. In fact, recently students at the University of British Columbia successfully advocated for its student council to formally urge the university to divest from companies on this UN database. So it's clear international advocacy and solidarity have been a linchpin in the promotion and protection of human rights. And it's really essential in holding corporations accountable for their violations of human rights. Now, frankly, these methods are slow and often quite dissatisfying, especially when corporate monopolies are able to continue profiting off of such blatant violations of human rights. But legal accountability is growing, both through jurisprudence and in international advocacy. And I do want to cut this short. I know there's much to talk about, but I will just simply say that ultimately what is most needed in entrenching greater human rights norms in the private sector is a cultural shift in how we look at the obligations of corporations, especially in expanding avenues for individuals to take claims against corporate actors independent of states, especially when states are unwilling or unable to act on their behalf. So these cultural shifts take time and they require a lot of determination and using advocacy tools and pushing for new ones. But it's really crucial that we push forward with this through international corporate cooperation and advocacy to make sure that human rights are at the center of all corporate accountability. And of course, there are lots of legal tools to be used, but I will allow James to go into depth on that. Yes, thank you.
Thank you so much, Kathryn, for providing insight on how occupation is profitable for some and how sometimes interests in accumulating capital supersede any morality or concern for human rights. I'm going to move on to James, who is a Toronto-based lawyer who is specializing in international and transnational human rights litigation, especially with regards to human rights and social responsibility of multinational businesses. He's been involved in many lawsuits seeking to hold Canadian companies accountable for their involvement in human rights abuses in their overseas operations. He has a JD from Osgoode Hall Law School, where he graduated with several prizes and the silver medal and a Master of Law from Yale Law School. After he finished his JD, he clerked at the Supreme Court of Canada for Justice Ian Binney. He's president of the Canadian Lawyers for International Human Rights, and he also sits on the board of directors of the Canadian Council for International Law, also known as CCIL. He will be giving us an overview of the Canadian context, the Nufson case, and its significance and other specific cases in Canada. He's also going to be talking about Canadian law with regards to business and human rights. So the floor is yours, James.
Great. Thank you, Tara, for that introduction, and thank you to my colleagues for their illuminating presentations. I'm going to now talk about some of the possibilities to try and hold corporate actors responsible for violations of international law in Canada. So just to kind of recap what Jonathan touched on briefly, and those in the audience who are lawyers, please bear with me. Remember that national laws and international law are on two different planes conceptually, right? National laws and international law, as Jonathan pointed out, are similar in the sense that they both rely primarily on voluntary compliance to maintain their integrity. The key difference is that with national laws, or at least with Canadian law, it relies on voluntary compliance, as well as it's got a little bit of an enforcement mechanism for those who don't voluntarily comply. Whereas international law, as Jonathan said, relies entirely on voluntary compliance. So the trick then is to try and use the enforcement mechanisms that national courts, like Canadian courts, have access to try and enforce international law, which has no real enforcement mechanism of its own. And this is tricky. You kind of have to be creative, because the thing is, at least with Canadian courts only apply Canadian law. So you can show up at a Canadian court and with Canadian law arguments and make them to a judge, and if the judge agrees with you, they'll make an order to enforce its decision. But it's not the same with international law. Canadian courts won't enforce international law. But there are arguments you can make to try and incorporate international law and kind of parcel it, package into Canadian legal arguments. You can use Canadian law as a vehicle to try and enforce international law. And so I'm going to talk about some of the ways that that's been tried, and some of the successes and some of the shortcomings. So I'm principally going to talk about a case that I was involved in as lawyer for the plaintiffs, called the Nevson case. I want to acknowledge the law firm Camp Fioranti Matthews Morganman and the law firm Siskins LLP, who took this case on with me. This involved a Canadian mining company that had a gold mine in Eritrea. Many of you, especially if you have a background or follow news in Israel, will know about Eritrea. For those who don't, it's a really repressive country, one of the most repressive in the world. It's a place that's got no political opposition or freedom of speech, or even a constitution, things like, a legislature, independent court system, free press. It's got nothing like that. It's really purely a one-man dictatorship. And one of the most peculiar and repressive aspects about it is what's euphemistically known as the national service system, whereby every Eritrean who reaches the age of 18 is conscripted into what's basically a forced labor system. So they're sent to do a job, they're assigned to do a job, and they can't leave that job under penalty of imprisonment or torture or worse. So you could be assigned to a general's or colonel's farm or factory to do manual labor, or you could, they could do an aptitude test and say, hey, you're a pretty smart person, a pretty good student. They'll send you to school and maybe they'll train you to be a doctor or an accountant or a lawyer or something. And then you'll be basically forced to do a job, assigned to a job and forced to do it as forced labor. So really awful conditions in this country. And basically into this country comes a Canadian mining company, decides to build a gold mine. And this Canadian mining company takes on a state-owned construction company, because the entire economy is essentially controlled by the state. So they hire a state-owned construction company to build the mine, and that state-owned construction company uses forced labor to build the mine. After a little while, news of this comes out. Human Rights Watch does a report, and myself and my colleagues filed a lawsuit in British Columbia courts against the Canadian company in Vancouver, where it's headquartered, on behalf of some Eritrean nationals who claimed that they were forced to work at the mine. It's called the Bisha mine. And these Eritrean nationals, they're people who have escaped the country because we can't work with people inside the country because it's really repressive, right? And we can't gather evidence, we can't enter the country, right? So we had to work with people who had escaped the country as refugees. They were living in places like Ethiopia, some in Europe, and quite a few actually in Israel, which is what I was talking about earlier. There are a lot of Eritreans in Israel, living in Israel as refugees, although they're not recognized as refugees in Israel. So we're working with these plaintiffs all over the world who had been forced to work at this Canadian-owned mine and had escaped the country. And now we're trying to bring a lawsuit on their behalf against the Canadian mining company that's at its headquarters in BC in Canadian courts. And one of the arguments that we made against the Canadian company is that they're civilly liable under Canadian law because their actions constitute complicity in international law violations, specifically violations of international law rules against forced labor, slavery, torture, and crimes against humanity. So basically, the defendant mining company, these are all novel arguments, right? Because in Canadian law, international law is it's not directly enforced, but I think there's a bit of a growing movement to try and integrate international law into Canadian law more, and I guess this case is part of that. So we made a novel argument that the company could be held liable for violations of international law. The defendant filed a motion to dismiss, saying that this isn't possible in Canadian law. Canadian law can't enforce international law in this way. You can't hold, there's no civil liability for international law. Corporations can't be liable for violations of international law. And this is all an affront to the sovereign state of Eritrea and its sovereign actions. Canadian courts don't have jurisdiction because these are the sovereign acts of a foreign state, and you can't bring this in Canadian courts. This should be filed in Eritrean courts, even though there's no such thing as an independent Canadian Eritrean judiciary, rather. So Canadian courts basically dismissed all these motions, and they accepted the jurisdiction of the Canadian court. They rejected the defendant's argument that it should be heard in the Eritrean courts because we successfully argued that just wasn't possible. And they also agree that, as a matter of fact, yes, Canadian law can enforce international law to hold corporations civilly liable through the vehicle of Canadian law. So this is something that may have relevance for Canadian companies operating in the occupied Palestinian territories, because there's a couple international laws as at play here, as at least I think Kathryn, possibly others mentioned. There's the settlements, which are a violation of Article 46, paragraph 2 of the Fourth Geneva Convention, and any grave breach of the Geneva Conventions is defined as a war crime under international law. So the settlements are essentially war crimes. The other one is the crime of apartheid, which is also a violation of international law. So any corporation that's complicit in either of these two acts is complicit in a violation of international law. So it should, in theory, be possible to file a claim against a Canadian company for complicity in one of these acts in Canadian courts. The only thing is that that's been tried before in Canada. It didn't work, and didn't work not because the Canadian court said you can't do this, because the Canadian court said, well, Canadian courts don't have jurisdiction. Canadian courts don't like to interfere. They don't just like take jurisdiction over things that happen in another country. They also don't like to get involved in disputes that are politically controversial. And if you give them a chance to basically duck a question like this, to not have to rule on something and not get into political controversy, and this is with good reason, right? That I'll acknowledge that they don't want courts to be politicized, right? But at the same time, if you give them a good reason to dodge a question like that, they'll take it. If you give them a good out, they'll take it. And this court said that, well, it should go to Israeli courts. Israeli courts, are, they're fair. They have ruled in favor of Palestinian rights from time to time, and so this claim should be in Israeli courts. I want to end, I guess, by tying back to what Jonathan said, because I believe he was going to come. We were going to circle back to him and just talk a bit about international law. And I agree with Jonathan. Well, actually, I do think it's a bit strong to say that international law is at its root, or was originally only concerned with states as subjects, because at the beginning, actually, for example, take the example of piracy. Piracy, robbery on the high seas, one of the oldest violations of international law. And that's always been something that's committed by a non-state actor. In fact, by definition, if it's committed by a state actor, it's not piracy, it's privateering, right? And this is because at the beginning, international law was derived from natural law, the sense that, it embodies some kind of universal principles shared by all humanity. And over time, a competing conception emerged that international law was just the system of rules between states, governing relations between states. And that became to be a very dominant international law. And these are the two competing conceptions of international law. They're not mutually exclusive entirely, but they're kind of competing in a sense. And I think we're trying to advance this idea that it embodies universal principles applicable to everyone. Because authoritarian countries like Russia and China, they're very distrustful of international law because they see it as a vehicle, as a trick, colonial trick to try for the Western powers essentially to impose their will upon others. And to a large extent, they're right? Because Western powers like the International Criminal Court has never tried or never prosecuted anyone outside of Africa. The Western powers always try to apply international law to others, but are unwilling to apply to themselves. The American conservative right is also the conservative establishment is also very distrustful of international law for the same reason. They're afraid of it being applied to American interests and for of human rights rules seeping into and being applied to American military actions. And so I agree with Jonathan that it's up to civil society, it's up to people like us to try and make arguments, legally or otherwise, that international law applies to our governments and the governments of our allies in order, and this is the only way that international law can have any kind of integrity as a legal system.
Thank you, James. Before getting to a question that I think all the panelists can probably answer live, I'm going to circle back to Jonathan. So go ahead, Jonathan.
Thank you very much. This has been fascinating. And I would like to pick up exactly where James left off. International law develops, and it develops through the practice of states and through the practice of individuals. Just a reminder that a lot of international law became codified and developed after World War II, when the world realized it. We can't just let countries go wild. We can't let governments do whatever they want to do. There has to be some enforcement. And the problem is that a lot of the enforcement mechanism was tied up with the Security Council, where the 5 permanent members retained the veto power. And even despite that great obstacle, there was increased efforts to create protocols for enforcement of the different conventions, for reporting requirements, and for a robust international order that monitors and follows up, particularly the more egregious violations. And there has been progress. The International Criminal Court was in fact created despite the efforts of the United States and others to prevent that court from being created. But something new has also happened. And this is important for all of us to realize. The Ukrainian war all of a sudden revived interest in international law. Perhaps because it is happening in Europe, perhaps because it is highly televised, and the victims are white and blonde and blue-eyed. All of a sudden, people are saying, wait a minute, these are war crimes. These are crimes against humanity. We have to activate the International Criminal Court. Even the United States, which resisted for many years having the ICC even be created, and which was threatening the ICC, all of a sudden it said, wait a minute, we have to do something. Corporations in the United States and elsewhere started on their own to act, to boycott, and to sanction, and to divest from the Soviet Union, from Russia, I mean. In addition, sports agencies, which for a long time have been saying, you know, sports and politics don't mix, and have been in fact sanctioning Palestinians who, or those who supported Palestine and Palestinians or refused to play against Israeli contenders in sports. All of a sudden, these bodies are now sanctioning and preventing, at least temporarily, Russian groups from participating in certain sports. So I think we have a new opening here to really activate the inherent power of ordinary people, ordinary citizens, civil societies, using not only local laws and international law, but also using organizing mechanisms and tactics to enforce human rights and human rights compliance. So if I were active in BDS, this is my wonderful opportunity to say BDS is not only legitimate and legal, it is also required of corporations and individuals to participate in boycotts and in sanctions and to divest from corporations that are violating international law. Thank you.
Thank you, Jonathan. So I'm going to move on to a really interesting question that I think everyone can answer. So someone asked that in the case of private corporations that are involved in the surveillance and defense technologies, so for example, like G4S, that are being subsidized by the occupations, by the occupation to maintain their regime and to expand their colonial apparatus, and are also being receiving investments from a lot of private groups from Europe and Turtle Island, or so-called North America, for profit and for new methods of control. How could these mega corporations be held accountable or be expected to change their ways when the way that they make profit is through the violation of human rights, particularly Palestinian human rights and sovereignty? And when they have this, when they have these opportunities for profit that the occupation provides for them in those fields. So anyone can jump in if you'd like to answer.
I think that's a very good question that was raised with regard to the issue of the surveillance technology. And the surveillance technology is one byproduct of this sort of best business practice of colonialism, in that the exploitation of the captive population, not only to use it as a captive market to sell to, but also to exploit it as a captive population for research and development, and maintaining control over the people to develop such technology using the occupied population as a laboratory. And unfortunately, that those products that are being developed under the umbrella of innovation are also finding markets abroad that are eagerly awaiting to purchase the development of such technology, because it's been field tested. It's been used on the ground against Palestinians. So the issue of the development component of technology, the R&D, I think is an area that warrants further exploration, because there's a lot of focus on sort of the end use of the technology, and then how it's used potentially to violate human rights. But there is less attention being paid to the sourcing of such technology and the coercive environment through which such technology emerges, that undermines the integrity of the science and ethics of science and research in the first place, which I think is a very interesting area that needs additional work on. But in terms of holding these corporations accountable, we've seen in our situation where one of our colleagues was targeted by Pegasus spyware. A company, an Israeli company, NSO Technology, has developed that. But these companies are also outgrowths of the Israeli military-industrial complex and specific intelligence units like the 8200 that use, again, this lab that they have of a captive population to develop such technology, spin-offs to private sector, and then reach to an international audience. And only when it reaches people that have the power and political will to do something about it is there pushback. And we've seen companies like NSO be sanctioned by different governments and creating, even in the US, and creating this sort of momentum to push back and challenge this. But it is definitely an uphill battle, but it is also part of that broader economic incentive structure.
Thank you so much, Wesam. If anyone else would like to add on to that, please feel free to unmute and jump in. If not, I'll move on to other questions in the Q&A. This question is for Jonathan. Someone asked if you're aware of the case of Stephen, sorry, I don't know how to pronounce this last name, but Donziger in the USA, who's a lawyer that won a case with other lawyers for an indigenous tribe against Chevron, and then was wrongfully sued by Chevron. Do you see this? He lost and was sent to prison, and the prison then refused to accept him, and he's currently under house arrest. Do you see this as a tactic to discourage other attorneys to file lawsuits against large corporations that are violating human rights?
Yeah, I think every country is a little bit different. And particularly in Western countries, you have to understand that there are a number of competing interests. They are not all nefarious. They are not all bad guys. But there are different competing interests. And sometimes it is laborious work, and sometimes it's tedious work, and sometimes it's highly technical work and highly legal work to maneuver these things to push them in the right directions. And there will be resistance, obviously, because there are other interests that are not interested, that don't want to promote international law, and sometimes it is hard work. So I would say that there needs to be a lot of creativity, and there needs to be a lot of political organization, and there needs to be also a lot of education. People should be aware of what tools are available, because you see, governments do sign international treaties, multinational treaties. They sign the conventions for the right of the child and for the right of women. They signed the Universal Declaration of Human Rights. That's become almost part of a consensus internationally. They signed the Convention Against apartheid, different forms of apartheid and discrimination. But these instruments aren't self-enforcing. They need people to work on it, to try it, and sometimes to be creative, like James said. Sometimes you have to come up with new ideas and new theories, and to challenge and to push the judges. And every once in a while, you will succeed because you are talking about things that are right. You are talking about values that are human. You are talking about values that are universal. It's very hard for judges to always say, no, no, no. Because sometimes, judges will say, yeah, we have to do something about this. Surely we can't allow this kind of evil to continue. And you have to answer their arguments. Are there other courts? There are no other courts. Even the International Criminal Court only has complementary jurisdiction, which means that before you even go to the International Criminal Court, you must prove that there is no other court that is capable or that of providing justice and redress to the issue that you are involved in. So this is, I can see that in the future, one of the big arguments that Israel will use against the ICC is, we have courts. Why don't you come to our courts? So you have to show that the Israeli courts have not been effective in providing justice for the Palestinians. I don't know if this specifically answers the question about the Stevens case, but it's a more important answer, I think. We have to work creatively. That is why we have to put resources. We have to join organizations like Just Peace Advocates, and we have to defend organizations like Al-Haq and Ad-Damir and others when Israel tries to criminalize them. We have to work against legislation like the anti-BDS legislation that is prevalent in many states in the United States, and which may also come to Canada as well.
Thank you so much, Jonathan. That was a really insightful answer. If anyone else would like to also provide their perspective, or maybe
I would like to, provide my perspective. And so I want to speak to the Steve Donziger case directly, and I'll keep it short because otherwise I'll get a bit agitated. But for those who aren't aware of this case, this is a lawyer who won a landmark lawsuit in Ecuador against Chevron for environmental destruction that caused injury to a community there. And he was later pursued very aggressively by Chevron and its law firm in the US, Gibson Dunn. And they alleged corruption in obtaining the Ecuadorian judgment. They got a witness, one of their star witness, basically. He and Kathryn Wesam, correct me if or you feel free to add to this. He had the witness, or Chevron had paid for the witness's immigration process to the US, and in return, the witness gave evidence against Stephen Donziger. This was the star witness. Once the immigration process was finished, he recanted everything. And Steve Donziger was still, with the help of a judge who was very sympathetic to Chevron, was still convicted and is still under house arrest, I believe. And actually, there's a movement to try and lobby the president to try and have him pardoned. So I encourage everyone to look that up, and if there's anyone they want to write to help advance that cause, then to do that. But yeah, this is, so to answer the question, this is something, it just shows that a lot of these companies will pull out all the stops, not just to defend themselves, but to aggressively go after the people who are going after them, not just the plaintiffs, but also the lawyers. So yeah, that's right. That's how it is. That's the nature of the work.
Thanks, James. So I think we're nearing the 90-minute mark. So I'm just going to go ahead and ask one last general question. It was sent to the chat, but to summarize, how do we hold governments like the American government and the Canadian government accountable and responsible for their war crimes, their crimes against humanity and peace, their interventionism, especially when they're so instrumental in supporting all of these crimes that the occupation commits against Palestinians, and are also essentially occupying indigenous land within their so-called illegitimate borders. So how do we hold these governments that were founded upon settler colonialism accountable?
I'll just begin this and then pass it along, but I just will say, like, this is an overall issue with the larger international human rights regime as it is, because it was built by colonized nations and nations who have historically been colonizers. And there is an intense lack of decolonization in the structure of human rights law and the entire regime of all of our accountability mechanisms thus far. And it is a very, very frustrating reality. And it's, it's difficult. It takes generations and generations of codifying, human rights and better human rights jurisdiction. But I think it's important to keep in mind that things do progress slowly and not always in the way we want. But just recently there was a big victory case with the Mosquito community. They brought a case against Honduras in the Inter-American Court of Human Rights over human rights violations from the state's failure to regulate the practice of dangerous activities by private companies in the lobster fishing industry. And the court actually ruled in favor of the fishing industry, of the community, and actually set business and human rights standards in the American Convention of Human Rights that other states then have to also abide by. And it's, I won't go into the interesting case law, but it's, this is precedent setting, and it is slow, and the United States is not a member of the Inter-American Court of Human Rights, but it does set it sets a precedent which will then over time be solidified. And it, as my colleagues have said, it takes years of international cooperation and advocacy and constant hammering and asking more from our elected leaders and from our judicial systems, in addition to creativity. I could say more, but I will happily pass it along.
Thanks, Kathryn. I actually think that was a pretty good wrap up. So I'm gonna also ask the other panelists to give a 2-minute wrap up or so, also in reference to this question, because I think this is kind of like the overarching question that we're constantly tackling. So if anyone wants to jump in, Wesam, if you'd like to start with your wrap up.
Sure, thank you. And I think you're right, Kathryn sort of hit the nail on the head with the challenges that we face. And I think it's important for us to keep in mind that this isn't, a linear path. We move one step forward. Those that oppose will try to push us back. The reason that corporate actors have continued to operate with impunity within the international sphere isn't by accident. It is because they are also playing a role in influencing how international law develops and evolves over time in order to maintain that space for continued impunity. And this is the challenge that of our time, is how to rein in, how to tame the corporation. because left to its own devices, it will not only continue to exploit, it will destroy the planet as a whole. And so our challenges, even though we might be focusing on Palestine today, the situation of Palestine is just a microcosm of global injustice. And the issues that the Palestinians are facing are things that resonate around the world. And I think if we come together and look at these challenges as a shared struggle, we can come and develop the momentum necessary to counter the power of strong actors like multinational corporations. Thanks again for the opportunity.
Thank you, Wesam. Jonathan, would you like to wrap up?
Yes, I'd like to just finish with a very positive element. We live in a world that is actually increasingly getting better. There is more acceptance of the concept of human rights. There is more equality between men and women. There is more understanding that slavery, apartheid, discrimination are wrong and are bad. There is a consensus that attacks on civilians and on hospitals are really wrong and should be ended. So I don't think we should give up too quickly. Of course, there are powerful forces, and they are powerful, and they are well-financed, and they prosecute and persecute those who are working for human rights. But generally, I think if you look at it in historic terms, how things were 50 years ago, 100 years ago, 200 years ago, humanity is moving forward. Sometimes it feels not fast enough. And sometimes if you are the victims like the Palestinians, you say, where is international law? Where is the international community? It doesn't seem to care about us. But the reality is there is progress forward, and all of us should be part of the movement of history towards greater rights, greater compliance with international law, greater controls against impunity. Increasingly, those who totally oppose international law are finding that they can't even move out of their countries because there is universal jurisdiction. They may be arrested outside, that their assets may be seized, like these big super yachts that are being seized all over the world. So I think that there is basis for hope, and there is certainly a basis for increased work as individuals, as civil society, as attorneys, as human rights activists. There is the opportunity to work more for human rights and for greater respect for the rights of others.
Thanks, Jonathan. The first thing that comes to mind is the Algerian people's struggle for 130 years for decolonization. It's only been 74 years for Palestinians, and I think we all know that Palestinians are steadfast in their resistance. I'm going to pass on the mic to James to do his wrap-up before we end this webinar.
Thanks, Tara. I just want to close by, I think I just want to emphasize a little bit the limitations of working with the law as a tool, because I mean, that question, I mean, that's a lot to ask of the law. I'm not sure that the law can do all that. I mean, there's a famous quote by Audre Lorde that goes around, you can't undo the master's house with the master's tools. And I think that's truer of nothing than it is of the law, because the law does nothing, it excels at nothing better than maintaining the status quo in terms of existing power relations. It can be used as a tool for change, but really change has to come from organizing, it has to come from people, from political advocacy. That's where the real change comes from. Lawyers will never be at the forefront of change. It's going to be people who are going to really be behind the change. Lawyers can catalyze change using the law, but they'll never really be the moving force behind the change. Think about, you know, the question, who are some of the greatest lawyers in human history? To me, you got to think about names like Mohandas Gandhi and Nelson Mandela, right? And these are people, I mean, some people out there probably just found out that they were lawyers. It's because they were lawyers who didn't really use the law in what they did, but ended up going another way and ended up achieving far more than they ever could have if they had just remained lawyers, right? So I just want to say it's up to, yes, you know, these are the tools available, you know, and they can be useful, but I just want to keep the larger perspective. Really, change comes from a broader political and popular organizing. Thanks.
Thank you so much, James. I agree completely. Thank you everyone for attending. Thank you to the panelists for your insightful presentations. I hope everyone has a good day. Ramadan Kareem to everyone who's observing. If you haven't broken your fast yet, like me, I hope that the last few hours are easy. And yeah, thank you.